Norman Kent, Chairman of the Board. Thank you, Norman. Anytime I'm standing up here, use it as an excuse to stand, move, twist, change your position. It's a good excuse. I really encourage it. You'll feel better that you did later. You should be probably like 2 glasses of water into it by now. Our speaker this morning on ethical and legal liability of attorneys representing cannabusinesses. I can see the blood pressure going up in the room at the same time. Happily, Lance Rogers is a man from the trenches, and I'm going to read this through fast because I don't want to edit it. It's impressive. Principal attorney for the law offices of Lance Rogers, APC, located in San Diego, California. Prior to managing his own law practice, was an associate attorney with Jeff Lake, APC, and Turner Law Group, APC. Law practice focuses on civil rights litigation throughout the state of California. 2009, successfully defended medical marijuana dispensary operator Jovan Jackson from criminal prosecution by the San Diego District Attorney. The resulting high-profile acquittal, oh, isn't that a nice word? Let me say it again, acquittal. And successful appeal, oh, the double whammy, paved the way for legal challenges throughout the state. In addition to criminal matters, Mr. Rogers has handled a wide array of civil litigation cases, including asset forfeiture, unlawful detainer, civil rights litigation, contract disputes, municipal zoning challenges. Additionally, Mr. Roberts represents Mother Earth Cooperative, the first medical marijuana dispensary licensed by the County of San Diego. It continues. He's taught. He's been there, he's been here. I'm not going to take more time. We're on a compressed time schedule. Let's do the best we can to move it along. Lance, the more you can compress, the better. And Lance, we love you, man. Come on up and educate. Thanks.
First, as Keith is putting a very simple PowerPoint onto the computer, I'll explain something real quick that Lenny just said. You go, successful acquittal and appeal? How does that happen? Well, it's 2 different cases. Just so that we're clear, Mr. Jackson in San Diego is now working on his 3rd trial for operating a dispensary in the city of San Diego. The first one was an acquittal in which the jury then gave a press conference afterwards to say how they felt about this prosecution. Then the prosecutor prosecuted him again for the same activity of running a dispensary. The judge denied the defense, and it went to the 4th District Court of Appeals Division 1, and we have People v. Jovan Jackson, which is now law, and now it's back in San Diego for retrial. Perhaps Mr. Rachel will be there and talk about what 11362.765 says about profit, because now the big issue is what the heck does profit mean? But it's been interesting to say the least. Okay, so this is like a slideshow, and then we push, let's see here, I'm sorry, let's see. Keith, what's the button to put it as a...
Make it automatic or just one by one?
Okay, here we go.
It's got to start there.
All right, thank you. Okay, from start. And again, I'd like to move things along because I know we're on a compressed schedule. And I also want to just say that I'm hoping that this will be sort of a robust conversation with the amount of history, experience in this room, and especially it being a normal conference, I'm sure I'm hopeful that it will be. I'm humbled to present to you today. I've only been practicing for 5 years, and I think the reason why I'm excited to talk about this and have a discussion is to get answers from folks who have been practicing for 30 plus years. Because we as young, new, normal members are given very little guidance from our bar associations. We'll go through that here. It's basically figure it out. Here's the rule, apply the rule, and be extremely careful because you'd lose your law license and you could go to federal custody and these sorts of things. So good luck with that. And you know, we post on the listserv and we ask questions and we rely on our mentors. And I want to thank you for, you know, if you've ever mentored a young lawyer in a real tricky ethical situation, because over the past 5 years, I've been thrown into some really hairy situations. I'm still licensed. I'm still walking around. I'm pretty sure I've been under investigation, if not continue to be under investigation. But that's fine. I've made peace with that. I agree with what Lenny said. I'm a criminal defense attorney who is working to put myself out of business as a criminal defense attorney. That's my agenda. Unfortunately, right now I represent you know, a lot of folks who in criminal cases, and then I'm trying to bridge the gap into becoming licensed and regulated in the state of California. I, you know, am so pleased to be in the free state of Colorado with a photo that you know, I have in my office right now of 50,000 people in Denver committing an act of civil disobedience and breaking federal law together. And again, what we'll start though is that marijuana remains a Schedule I substance under the Controlled Substances Act. So this is basically a guide of what we'll be discussing this morning quickly, and it's also in your packet. Again, introduction, my name is Lance Rogers. I'm still licensed to practice law, and hopefully will be so for the next 25 years. Federal law. Marijuana is a Schedule I substance under the Controlled Substances Act. In my office, I have a sign similar to many hydroponic stores in California that says this, and I have documentation everywhere in case anybody ever wants a question. Geez, Lance, are you ever not informing people about federal law? Well, it's on a big friggin' sign in my office. So, you know, unless you know you missed the part in our conversation and in our documents, then you know maybe you saw the sign when you walked in. Obviously, there's no medical marijuana defense or necessity defense under federal law, and there has been no advisory opinion as to lawyers from the American Bar Association or the Federal Criminal Defense Bar, to my knowledge. And again, please, I did as much research as I could, but if I'm wrong, please let me know. So again, as to federal law, we as lawyers are left to figure it out. And I don't often quote Bible scripture ever, but I think the main dilemma that we're faced with is, you know, I've heard it remarked with no man can serve two masters, which is a, you know, from Matthew 6:24. Another lawyer I respect, you know, quotes that frequently with the dilemma that we're faced. I was having a conversation this morning at breakfast. Well, you took an ethical oath, federal law, state law. So, you know, what the heck? What about federal law? And I think we're confronted with this dilemma, and a reasonable and safe interpretation is don't do it. There's the door. You know, somebody comes in, look, it's illegal under federal law. I'm a lawyer, and that's it. And that is important, and I want to get into that when we talk about some of the hypothetical situations. But we have 3 ethics opinions from 3 different states, which we'll be going through, and those ethics opinions have said you don't have to just stop there. You can say it's illegal under federal law, but let's talk about state law. But I'm not going to help you break federal law, and that's been my interpretation. But I'm hoping to have a robust conversation here, like we talked about. There is an ABA journal from December 2010. Matt Cuman, Jeff Lake, and Brian Vicente are quoted in it. Feel free to email me if you'd like a copy. But it basically talks about these dilemmas, and there has been a criminal prosecution of a lawyer in 2012, but it is my interpretation that was not as a result of him acting as a lawyer, and we'll get into that. That's been talked about on the listserv. So, federal law. there it is. State law. We have 3 ethics opinions from various bar associations throughout the U.S. In July 2010, we have the main ethics opinion, and that is available online, easy to find. I was reviewing this morning, and I think, you know, we have kind of, I don't want to say the good, the bad, and the ugly, but we have kind of like lukewarm. That's Maine, it seems to me. Kind of dip the toe in it a little bit, and there are 2 general themes that I see from that opinion. One, when the proposed client conduct violates federal law, the attorney's role is limited. So they want to emphasize that this is a different type of scenario than if you're advising clients engaged in other types of conduct. And an interesting point that they also make is that it's important to realize that there's, at least in terms of the Maine Bar Association's interpretation, not a distinction between non-enforcement of the law between crimes that are enforced and crimes that are not enforced. Because obviously, as you saw from the photograph of 50,000 people breaking federal law together, I mean, I guess we could argue about whether use or simple possession is enforceable in Denver. The big issue is always enforcement of federal law. And Maine in 2010 said, well, look, there's no distinction between enforcement and non-enforcement in that opinion. They do, however, go into a little bit of advice. Again, they leave us with what we hear from the other 2 bar associations. They leave off, we cannot determine which specific actions would run afoul of the ethical rules. So again, you know, no real guidance, but just giving you the rules and then telling you that there's, specifically they say there's a critical distinction between presenting an analysis of legal aspects of questionable conduct and recommending the means by which a crime or fraud might be committed with impunity. And we see this theme throughout the other 2 ethics opinions as well, which is conversation about a legal analysis, discussing the law, and then putting yourself in a position where you're in fact aiding and abetting in assisting someone in breaking federal law. And it's my opinion that's where it's at. You know, for federal practitioners, you know that there's in fact a sentencing enhancement for abuse of a position of trust under federal guidelines. So we as lawyers are in a position of trust or have a special skill, and it's my interpretation that if we use our superpowers, our special skills, of all of our 30 years of experience of being around and listening and reading police reports, that there could be an allegation, and then we use that knowledge to help somebody evade detection or violate federal law, then that might be a line that's crossed. I'm interested to hear your thoughts on that. But I think that basically gets to some of the issues that the Maine Bar Association discusses. Yes, please.
My thought is it's a mistake to ask the state bar to issue an opinion on the issue.
That's an excellent question, and please just feel free to just shout out whenever you have a comment or a question. I want this to be interactive. So again, if you didn't hear, the comment was, it's a mistake to ask the Bar Association for an opinion, and I think that's a very good point because actually I don't know the history if it was asked of Maine. But it was asked of Arizona, and I will tell you that I think Arizona is very helpful for us. And I'll get there in a minute. But then Connecticut, I don't know if Connecticut was asked for.
Yeah, Connecticut was asked. I
Right.
think there was a large law firm that asked, because whenever I ask them for guidance, they don't answer me.
So Connecticut was asked for, and it's bad. So that's a very valid point. But I think Arizona was also asked for, and it says some great things. I mean, again, in the published Arizona ethics opinion, you get this from a state bar association. They say, history is replete with examples of lawyers who, through vigorous advocacy and at great personal and professional cost to themselves, obtained the vindication of constitutional or other rights long denied or withheld, and which otherwise could not have been secured. You know, so you have a bar association, echoing some themes that you heard from the speakers this morning, like, go out, civil disobedience, help people to change the law. So
isn't it somewhat of a John Brown argument? Like, hey, John Brown was violating the law when he was freeing slaves.
Right.
He was trying he was violating the law. He could have been prosecuted. It's the same argument. We're assuming that the federal laws are constitutional, and they're not.
Well, that's part of the bigger
argument
conversation.
Is, hey, I'm representing my client and trying to help them out. The federal laws are constitutional, and give us a few more years, just like John Brown was proven right, will be proven right.
Right.
And I mean, the follow-up question to that is, all this real comfortable saying the law you're being prosecuted under, client, is unconstitutional. We'll argue that on your behalf. But is it just as ethical to say, I believe this law is unconstitutional, so your business model should violate this law?
I'm sorry, run that by me again.
When we're defending clients, we always argue certain laws are unconstitutional.
Mm-hmm.
And we do that in good faith and say the law should be reversed. We're real comfortable with that.
Yeah.
But what about the flip side? Say, client, your business model violates an unconstitutional law. This is how we can get around this constitutional issue.
Okay, is that then advising an individual to set up a corporation that would be
To
unconstitutional?
violate an unconstitutional law, as you told us.
Okay. I mean, so it obviously goes both ways. Are you setting up a corporation to aid to evade detection from federal law, or are you setting up a corporation to test this law? Or maybe there's a third, factor that I didn't even consider.
Well, in California, there's an ethical rule that says no member shall advise the violation of any law, and presumably that includes federal law. But I don't do advising companies, but it seems like this kind of the way to really couch it would be to say, I'm not advising you. What I'm advising you is on how to adhere to state law. I'm not going to advise you on how to run your business. That would be nice if you could do that.
Yeah.
But that's really, I think that's maybe where the line draws. But if you're giving legal advice on how to adhere to state law, and clearly I think you're obligated to say, but this conduct violates federal law, and you should know that. And I'm not advising you to do it.
Yeah, I completely agree with that. If you didn't hear that, a critical distinction may be the difference between advising someone on adhering to state law and advising them how to run their business.
I think we need to work on changing the phrasing. I think we have to stop saying, of course it violates federal law. I think what we might be saying is, the feds believe and will act as if it violates federal law, and some will argue that it violates federal law, but there's an argument that it doesn't violate federal law. You'll be prosecuted, but stop with this, it violates federal law.
I don't.
Step
Can
back from that.
let me just tell you, I'm concerned about that because I have heard of individuals who have misunderstood legal advice that federal law is not in effect, and then engage in conduct and then get busted, and so that's my only concern, is that as a lawyer I don't want to use my superpowers to say, oh, don't worry about federal law, go break California law, because it's
I think we have to say, worry about it. But it's just that single sentence. Of course, everyone knows it violates federal law. That's taking a big step, and it's a step that we don't want to encourage while being clear that the feds sure will prosecute and think it violates federal law.
What about advice on risk management, such as keep it under 99 plants or less?
Well, this is so fascinating too, because this goes to the heart of the matter, in my opinion. A possession of a joint is at least on national forest property, is a violation of federal law, right? So it's about and so there's this sort of 99 plant rule that people are throwing around all the time. Oh, if you keep it under 99, you're fine. Listen, in San Diego, the Narcotics Task Force, I have a client, 2 elderly folks right now. She's suffering from a terminal disease. They're in their mid-60s. They're doing 29 plants. And they are being prosecuted. Now, it's stateside, but it's Narcotics Task Force with federal involvement. On the flip side, I had a case with 283 plants in 2 grow houses, and that was also prosecuted stateside. So, it's a very difficult, for me to advise on risk management. Oh, if you keep it under 99, you're going to be fine, because that's not my experience in San Diego.
But you can talk about trends, you can talk about what you've seen, and you can talk about how there is no guarantee on anything because, well, it is against federal law.
Well, that's an interesting comment as well, which.
Unless you're completely in line with everything from state law, the advice is you will get busted. I mean,
But I wonder if that's acting in your capacity as a lawyer, though, too.
We don't get, in Colorado, we're very fortunate. If you're in strict compliance, you're not getting busted. That's not what they are.
Well, that's a whole nother.
Okay, up here in front.
Okay, so I'm from Seattle and I've been struggling this for the last 9 months. And what I think is very helpful for the clients is to chart out, here are all the federal penalties and here's everything that's illegal federally, and have a very documented, here are all the laws you could be breaking, and have them initial it so they're educated to, hey, if you have a handgun, that ups the federal min-man. If you've got 99 plants, and then you have a big disclaimer, I cannot help you avoid any of these, but you've just given them every single federal thing that they could know about, and that was how I sort of reconciled it.
And I think that was discussed at the last conference last year too, was this notion of a disclaimer and just making sure that it's that you're protecting your own liability too, and just having it in writing. Just so that we can move through the guidelines and then maybe open up to a Q&A. Again, the Arizona ethics opinion is good for what you do, and because it gives you a consistent answer. It states that whether a lawyer may ethically counsel, the answer is a lawyer may ethically counsel or assist a client in legal matters expressly permissible under the Arizona Medical Marijuana Act, despite the fact that such conduct potentially may violate applicable federal law. Lawyers may do so only if, 1, at the time the advice or assistance is provided, no court decisions have held that the provisions of the act relating to the client's proposed course of conduct are preempted, void, or otherwise invalid, still valid law. 2, the lawyer reasonably concludes that the client's activities or proposed activities comply fully with state law requirements, so easier in states where state law is clear, like Colorado. And 3, the lawyer advises the client regarding possible federal law implications of the proposed conduct if the lawyer is qualified to do so, or recommends that the client seek other legal counsel regarding those issues and appropriately limits the scope of the representation. So if you're qualified on federal law, you can say it, but you can also take a more cautious approach too, and say you need to speak to a federal practitioner as well before engaging in any of this conduct.
Can I share about Arizona?
Please.
The reason the Arizona opinion is so much better than the main opinion is because of the NORML legal committee.
Yeah.
The NORML legal committee met in Key West and had people on the phone elsewhere and organized around that. And we worked with Tom Dean locally.
Yeah.
And we brought in this ethics professor from California who had an opinion.
Yeah, Jeff Hazard. Yeah, and so that's we got to give a shout out to the people that.
The kind of things that
that's right.
everybody can do when we work together instead of.
Oh, absolutely. So again, you go, okay, do we ask for an opinion? Because there's a risk that we could get something like Connecticut. And I guess I would also say that if you do, make sure that you're going in to be an active participant in that process with a law professor who is quoted in the ethics opinion with a significant amount of participation in the process, because you can't have a successful ethics opinion for the practice. Because in Connecticut, they really, you get a very narrowly focused opinion that states that once a lawyer discovers that client conduct the lawyer considered legally proper is criminal or fraudulent, the lawyer must end his or her assistance. So the challenge is, okay, so the client comes in and says, I want to get involved in the process of getting a license in the state of Connecticut to have a medical marijuana dispensary. And says, well, okay, at a certain point, you have to cease your representation. Well, okay, is that when he tells you the word marijuana? There's the door, because now you're really not giving him any legal advice. Or okay, do you go, okay, well, I'm going to help you get the license, but then once I know that you're actually going to start growing marijuana or selling marijuana, now I need to stop. And then, or how about, you just set them adrift with the license, and then they call and say, geez, I have this issue with employment law or immigration or child. Well, I can't talk to you about that. So, and again, lastly, they just leave off with the general, you have to, we're not giving you a specific answer, figure it out yourself. But be very cautious because it's extremely risky. Lawyers should carefully assess where the line is between those functions and not cross it in Connecticut. I know that there was lots of concerns. It seems like any time there's a lawyer involved in a criminal case, obviously I think it raises everybody's blood pressure, as we talked about. There was a case in August 2012 of Nathan Hoffman. Does anybody know Mr. Hoffman in this room? Maybe we should. Okay, so there is somebody who knows this lawyer. He's still practicing. I looked him up this morning, so he's still practicing. But I went through, and some of the activities that Mr. Hoffman was involved in, in my opinion, and maybe I'm mistaken, but got more into becoming a principal in this than just becoming being a lawyer and giving legal advice. For example, he created a general agreement that contemplated a 25% interest in an indoor legal medical marijuana franchise cultivating approximately 900 plants in exchange for $50,000. According to the cooperative check register, the company received numerous loans ranging from $100 to $3,200 from Mr. Hoffman over a 2-month period. The IRS agent formed the opinion that these loans represent a significant investment in the business. Hoffman was listed as an employee of the business in an internal document. He was listed as the manager of a prior venture. He maintained a bank account for the entity. Over a 15-month period, a total of $2.4 million was made in deposits into this account, $1.6 million in cash. A PG&E account for one of the grow sites was in Mr. Hoffman's name. And I stopped at the last one, which is that he had purchased clones using one of his checks. So, we never want to see, obviously, a lawyer get involved in a situation like this. But I think, some of his actions went beyond, what we do as lawyers. But he's probably still fighting his case and is still licensed to practice.
What was he charged with?
Oh, that's an excellent question. Thank you. He was charged with conspiracy under federal laws, a federal case, federal indictment. I'm sorry.
Cultivation.
I believe it was cultivation and distribution. Yeah. And then he was also charged with this sentencing enhancement for abuse of a position of trust or use of a special skill, which is a base level 2 increase for his overall exposure. So that's troubling.
Did they bust the business and then find his involvement is what happened?
Yes. In the Arizona ethics opinion, there is a case cite from In Ray Smith from 2010. I apologize, it's not listed there. It's 348 Oregon, OR, 535. Oregon colleagues probably may know about this, but the Oregon court suspended for 90 days a lawyer for misconduct in representing a former employee of a medical marijuana clinic who attempted to physically take over the clinic. The court concluded that the lawyer gave the client frivolous advice, lied about having authority for the client's acts from a governmental entity, and engaged in a criminal act by accompanying the client when she attempted to occupy the clinic. The lawyer met the client when he was a patient at the same clinic. And so, again, that is a professional administrative hearing type context for a lawyer in a medical marijuana context from 2010. And lastly, in California, one of the things that I was thinking about when I was preparing this was Health and Safety Code 11370.6b, and there may be similar statutes in other states. The general statute is possession of more than $100,000 related to a transaction involving proceeds of a controlled substance, and there's a separate subsection for an attorney's possession of more than $100,000 related to transactions involving proceeds of controlled substances. In California, for the attorney to be charged, they must find that the attorney intended to aid the illegal activity or to disguise the source of the funds. It's wobbler, so probation or prison, and so that we have that in California. Perhaps there are similar type of crimes in other states. So to move things along, the last thing I thought might be helpful is to come up with some possible scenarios, because all of the ethics opinions say each attorney has to come up with a certain scenario and decide it on its merits. So I've been thinking and discussing with other lawyers about things that arise in the course of representation. Some of them are corporate formation, forming a corporation like we just discussed, for a marijuana business, a medical marijuana business. One of the issues that was discussed was, if you file a general articles of incorporation that doesn't state anything about the intent of the corporation, are you aiding and abetting in what that corporation is, or should your corporation list the specific intent and use of what that corporation does? I think this is a conversation that occurs with lawyers in California, some of whom have a general incorporation and some of whom specifically mention cannabis, which you can do through the Secretary of State. Commercial lease negotiations. Professor Wald, this was at there was a conference in Colorado in 2012, February of 2012, at which Professor Wald from Denver, probably you folks know him, took a position with regard to lease negotiations that it would be the substantive assistance in violating federal law. If you were to assist a marijuana business in getting into a lease. That's an interesting interpretation. Regulatory compliance and licensing. This has come up in San Diego. Again, I represented a dispensary that was licensed by the San Diego Sheriff's Department. And the question arose whether the dispensary had a duty to disclose federal law to its members. We had this come up recently in Mendocino as well. The duty to advise people that if they participate in a local regulatory scheme, that they could put themselves on the radar, or you're giving your information to a state or local entity, which could be subject to subpoena from the federal government. Those efforts have been litigated.
Where is that? Where are they? Are they
Mendocino?
They still fight the subpoena?
I think it's it's public information to state that the matter has been resolved via settlement. I believe the county of Mendocino will represent that wasn't everything. The groups filed a motion to quash in federal court, and the county did, and then grower groups did, and it's been settled out of court. Contract negotiations and drafting. This is an interesting one. Matt Human posted on the listserv about the illegality doctrine. I have a couple of civil cases right now in which individuals have loaned money, contributed money, however you want to call it, to a venture, and then something happens to the venture and say, okay, well, I'm going to take you to court. And one of the challenges in court is, again, illegality. you have an issue with a judge enforcing a contract involving marijuana. And so we spoke a little bit on the listserv about the value of mediation or arbitration clauses in these types of contracts. And again, before engaging in one of these things, if you say, look, we recognize we're going to have issues in court, so let's agree to mediation in the event of a business dispute. But then the question becomes, okay, well, again, contract negotiations, is that substantive assistance in violating federal law? Perhaps Professor Wald, might think so. Employment law advice. Does the business have a duty to disclose federal criminal risk to employees of a dispensary? In San Diego, on the second Joe Von Jackson trial, there were two defendants, Mr. Jackson and a security guard who was hired 2 weeks ago. Shows up to do his job, and now all of a sudden he's charged under state law with the marijuana offense. Similarly, under federal law. Business litigation, again, getting back to the illegality doctrine. And then lastly, I think this one comes up a lot, which is conflicts of interest regarding representation of the corporation, its officers, and or its agents. I think that there's an attorney that has a very strong opinion about this conflict of interest, and it's it's a conversation. If you represent the business, what does that entail? The corporation, its officers, its employees, and is this an actual conflict of interest, a potential conflict of interest, a waivable conflict of interest? I've spoken to many lawyers that have had this issue in the past, and I think it should be discussed, and it might not be a simple answer. So, okay, so to move things along, that's the guide. But if anybody has any comments or open to discussion, yes.
Well, what about a law firm or lawyers who are associated? One of them advises the business on formation, then they get busted, and another member seeks to represent them in the criminal prosecution.
Yeah, and I've seen that throughout the California. And the question is, okay, law firm, you set them up, and then you represent them when they get busted. Good business, but is that ethical? I understand that. Yep.
Well, the member may be called as a witness in the
yep.
case.
The member might be called as a witness. The director might be called as a witness. The lawyer might be called as a witness.
How could the lawyer be called?
At some point in time, it might be important for the lawyer for the corporation to cooperate with the prosecuting agency. Possibly, maybe not.
I can describe a different situation.
Perfect example.
Okay.
Montana, Chris Williams went into an agreement with 4 partners. One of them was an attorney who advised him that you could do this and you wouldn't need to worry about federal law if he complied completely with the state law. When the attorney got busted and was charged in the indictment, the attorney cooperated so that he could get probation, and Chris Williams got the 90-year sentence.
So yeah.
That's what happens.
Right.
I just had a case in Ventura County with that very scenario. 2 lawyers, one set up the businesses, the other one was going to be the defense attorney. Somewhere along the line, they decided that maybe that was a conflict of interest after the big bust happened. There were co-defendants, and the other guy's lawyer called the lawyer that set up the businesses as his witness, defense witness, to kind of explain the formation. It was very complicated. Before the day was over, names don't matter. Before the day was over, that lawyer had to invoke the Fifth Amendment, was being called a co-conspirator and a perjurer. Their partnership dissolved, and, excuse me, I'm not sure, the guy who got himself in trouble, I'm not sure where he is at this moment, status-wise as a lawyer, but, I mean, witnessing that happen firsthand, there's just multitudes of ethical issues that arose out of that.
Yeah, I had a case where I was representing a principal got busted. And he was relying on advice from his attorney, another attorney. And the defense, the charge is conspiracy, and the defense is that I was relying on legal advice, therefore I didn't intend to violate the law. The lawyer told me what I was doing was legal, and therefore you're compelled to contact and subpoena the lawyer who advised, which is a cautionary tale.
So, I mean, this is, again, lawyer as witness, and again, that's why I think, number one, as we talked about earlier, I am concerned about, you know, a client coming in and having any ability, believing that it's legal under federal law, because, you know, then you're right.
Yeah, but these were state law. Even though it may be legal under state law, they still could get busted, right. And then the lawyer becomes a witness.
Right. I think, you know, I have to be fair to other lawyers that I've spoken to. Other lawyers take the position that, again, this is an evolving area of law, and the position on these cases is that what everybody is doing is lawful under state law.
Well, I don't want to take up that much time myself, but I also, I mean, I don't advise people on businesses, but I discuss it from the fact that, I mean, I'm actually looking for potential agreement on this. Even under state law, at least in California, the medical marijuana laws were not written as a shield against having them break down your door, drag you to jail, pay the bail, and be prosecuted. They are a defense after all of the terrible things have been initiated against you. That is all they can ever, will ever be under the current status of the law. I mean, I'm talking about state law. No matter how you set up your dispensary, your collective, your cooperative, your grow, whatever, no matter how much paperwork you have, no matter how many lawyers that advised you, ultimately they can drag you by the collar and force you to defend yourself. Do you A, do people agree, and B, do you think that that's something that not just the federal law advice, but telling people, look, I can tell you all these law things, right? But none of that's going to stop them as they're putting the battering ram through your door.
Yeah, I would agree with that, and I have that in my disclaimer. Federal law and state law, because you're absolutely right. In California, it is limited immunity to prosecution. And so you can still get prosecuted, and people do all the time. You know, I'm hopeful that perhaps in August this year that will change, because it seems to me as if, you know, the people of the state of California don't realize that.
No, they don't.
Yeah, I mean, they believe that it
is
is legal that you have a right to purchase, grow, sell, use marijuana, and also that you have a right to run a business. And as we saw from the California Supreme Court a couple of weeks ago, that's not necessarily the case.
Well, there's one sentence in the Health and Safety Code of California. It's in 11362.81 subsection D. It says, and they got around to doing this in 2004. Jerry Brown, who's the Attorney General, finally addressed it 4 years later when he put out these guidelines. But that sentence says, the Attorney General shall develop and adopt guidelines for the safety and non-diversion of medical marijuana for medical use. He put out a letter, an 11-page letter that's headed with that exact title. And Michael Bryant, the problem is it's not a published opinion from the Attorney General. Yet one would conclude that if the code states the Attorney General shall develop and adopt these guidelines, and then you point to the guidelines, you're looking at specific instructions from the Attorney General that's intended to go hand in hand with the Health and Safety Code. Then you get to court, and the judge says, well, it's not a published opinion, how are you going to cite it? Well, it's attached. It's attached as the August 25th, 2008 memo. And it doesn't count as citable anything. But there are specific instructions on how you're to run these businesses. And that's where the problem is.
right, I agree. So maybe there isn't any agreement for California, but
well, and there's also I'm sorry to interrupt you, but all of that's great, but then of course the big issue in California is, profit, which, you can explain all day long to the DA or whatever, well, if it's been set up right, it's got this stuff. They'll just say, well, one thing is just doing it for profit. That's become their fallback position. So unfortunately, it's still just, it's defending in court. Anyway, I'm sorry, go ahead.
Let's take one more question in the front row here.
Here's another issue that Seattle's had a hard problem with, and it's divided the lawyer community into two camps, which is, okay, do you say they call you a criminal, so act like a criminal and have no documents and do your business, don't pay taxes and don't have a business license and be very underground, or do you go the full route, come fully brightly out of the court